Selective Service System, SSS.gov. Alternative service cases. Okay. Relevant positions set forth by the courts. In addition to sincere objection to all wars based upon reason of religious training and belief, as set forth in subsection 3806J, this definition of conscientious objector extends to those whose belief emanates from a purely moral, ethical, or philosophical source. Walsh versus United States 398, U.S. 333, 1970. We certainly do not think that subsection 6J's exclusion of those persons with essentially political, sociological, or philosophical views or merely a personal moral code, citing subsection 6J of the University Military and Training Act, the precursor of subsection 3806J of the Military Selective Service Act, should be read to exclude those who hold strong beliefs about our domestic and foreign affairs, or even those whose conscientious objection to participation in all wars is founded to substantial extent upon considerations of public policy. Walsh at 342. To be exempt from service as a conscientious objector, a person must oppose war in any form. Objection to a particular war, but not all wars, is not sufficient for purposes of exemption under subsection 3806J. Even if an objection to a particular war is based on religious beliefs, see Gillette versus United States 401, U.S. 437 and 443, 1971, citing Walsh. However, in Secrella versus United States, the Supreme Court held that Jehovah's Witnesses who opposed participation in all secular wars but was not opposed to participating in theocratic war committed by Jehovah fit the definition of conscientious objectors because no such war was occurred since biblical times, and shooting wars, not theocratic wars, were the Congress had in mind when drafting subsection 3806J. See Gillette at 44647, citing Secrella 348, U.S. 385 and 391, 1955. Willingness to use force in self-defense in defense of home and family, or in defense against immediate acts of aggression and violence towards other persons in the community, has not been regarded as inconsistent with a claim of conscientious objection. See Gillette at 448, citing United States versus Houghton 413 F2D 736 740-42, California 9, or CA 9, 1969, United States versus Carroll 398 F.2D 651 and 655 CA 3, 1968. Persons who oppose participation in all wars but concede that the present convictions could possibly change in the future should not be denied conscientious objector status solely on the admission that they cannot guarantee that their consciences are unalterable. See United States versus Owen 415 F.2D 383 and 390 CA 8, 1969.